Good morning, everyone, and welcome to our webinar. Today's webinar is on when contracts fail, legal strategies to protect your business. My name is Mike Mullins. I'm one of our senior legal solutions consultants here at LegalVision, and I'm pleased to introduce our experts on the webinar today. We have Kathryn Wallace, our practice leader, and Natalie Casey-Wyness, one of our associates here at LegalVision. Now, before we begin, just a general bit of housekeeping. You will receive the recordings and slides in the email. So I know you probably want to take a few notes, but don't be too frantic because we will send everything to you afterwards. And please feel free to submit your questions in the Q&A box, and then we'll get to these at the end. And finally, please feel free to complete the feedback survey after the webinar. This is really valuable for us. Now, by viewing this webinar today, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business moving forward. To claim, it's really easy. Just leave your contact details in the survey that appears when the webinar ends, or just contact us directly through the website. We'd love to chat. Now, we do have a bit of a poll today, so please feel free to have a think and answer this while I hand over to Kathryn Wallace, who's going to talk through the agenda.
Thanks, Mike. So today we will be discussing contract drafting best practices, early warning signs at the beginning of a contract, early warning signs during a contract, and then risk management for negotiations, mediation, arbitration, recovery and enforcement options, debt recovery options, court judgments, security, and then, as Mike has said, we will finish with a short question and answer session. Great. So based on our poll results, it looks like most of you are here to learn, and it's also a tie with recovering unpaid debts and enforcing agreements. So hopefully we can provide you with some valuable information that can assist you going forward. So now I will speak about contract drafting best practices. So when parties enter into a contract, they do not do so with the intention of it failing or with issues arising. Everybody wants it to progress smoothly and cleanly and have a nice, happy, working commercial relationship. However, the unfortunate reality is that problems do arise and disputes also do arise. And whilst no one wants to enter into a contractual relationship thinking about how it might go wrong, it is something you should be considering each time. So when you're entering into a contract and drafting that contract, you should think, what could go wrong in this particular situation? How can I protect my business if it does? And in what ways can I remove, lessen, or mitigate any risks in the contract? Now, obviously, you cannot cover off every scenario or eventuality, but there are some key strategies you can implement in your contracts and your approach to your business relationships. One of these is ensuring that your contracts are well drafted and include essential clauses which cover key dispute areas and major risks. Some of these clauses I will set out shortly, but key is that your contract should be well drafted in clear and plain English so that they're easy to read and understand by both parties and there is little room for ambiguity. Essential clauses that you should be including in all of your contracts are the allocation of responsibilities, so which party is doing what. For example, if the contract is for the supply of goods, then who will be arranging delivery or collection of the goods, who will be supplying those goods, to what standard, how is payment going to be made. It's all very important to make sure that you're documenting the practical aspects of that relationship and how it will work. Are there industry standards that you can refer to? These can be very useful to avoid disputes over quality or quantity or assurances if there is a set objective industry standard that can be pointed to. Another key issue that we do often see arise is intellectual property. So who will own any intellectual property that is developed as a result of that contractual relationship? Will it be you or the other party? It is quite common where the party that is paying for, say, the services or something to be commissioned, they will then own the intellectual property versus an alternative arrangement where if you are creating those goods and services, you would own the IP and then the other party gets a license to use them. Also key is considering how each party can use the other's existing intellectual property. So this is things like your logo or your brand. Will the other party be given the right to use that, and what can they use it for? How long for? What are the arrangements there? Normally, we would recommend a limited use right, so for the term of the contract, where the license is revocable by you, cannot be used by anybody else, and in very particular ways. For example, your branding can only be on approved marketing materials. That would be another key issue where we do see disputes arise in terms of use of other parties' IP, particularly where reputational damage is involved. Also key is payment terms. How much will be paid and when, and what happens if payment is late. Commonly, we would recommend you include a provision if you're a supplier of goods or services, for example, which allows you to charge default interest on overdue payments, recover your costs of enforcing payment, and engage a debt collector. You should also be suspending the provision of goods and services until you're paid, so you're not essentially working for free. Term and termination are also key. So what happens if things go wrong? How can you get out of the contract? What also happens when it comes to an end? So you should be considering provisions specific to your arrangement. Have you given the other party the right to use something of yours? You should be saying that it's clear that they must return it to you when that contract comes to an end. Also common are restraints. So will you be stopping the other party competing with or employing your employees during the contract and after termination? Is that really important to protect your business should something go wrong and the contract ends? Very key is liability. So what is each party liable for under the contract? And we normally see these clauses being the most hotly negotiated, particularly around the giving of indemnities from one party to another and allocating the risk of what party wears what risk when a contract comes to the end. We would always also recommend that you are capping your liability to a certain amount. So whether that's linked to the amount your insurance would pay out on an event, the monetary amount under the agreement, or a monetary amount that you select, it's really important that you have that certainty so that if something goes wrong, you know how much it may cost you. Also key are dispute resolution clauses. So how will disputes be dealt with under the contract? Natalie is going to speak on this in more detail shortly, but from a contract drafting perspective, it is best to set out clearly what will happen if a dispute arises. We would usually include a process whereby parties agree to meet first to discuss and see if they can resolve the dispute before heading to mediation, and then if that fails, it's often arbitration or court, both of which are binding. It's also important to specify the governing law of the contract so it is clear which law will apply should you enter into a dispute and start needing to look at the relevant laws. You may also want to cover off specific scenarios relevant to your business in the contract. As noted previously, you cannot cover every eventuality. But if there are known issues that commonly arise in your industry, it is best that these are dealt with in the contract at the start and clearly. A clear and well-drafted contract which covers the key clauses noted above is a good start and a preventative measure against future issues that may arise. One other thing we would recommend alongside a well-drafted contract is ensuring that you have appropriate insurance in place to protect your business should something go wrong. So we've covered key things to include in your contract drafting, and now turning to the early warning signs that a contract might fail prior to you even entering into it. So some of the red flags that we do see during contract negotiations, and it's important to say that not a single one of these is necessarily a red flag by itself, but it's looking at the picture as a whole. And if there are a lot of these red flags coming across from the party that you're negotiating with, then you may want to either insist on further due diligence or walk away from the contract altogether. So key early warning signs are slow or inconsistent responses, so a long time for the other party to reply to you, and when they do, the answers are evasive or they avoid direct questions about key commercial terms. The other thing that we do see is different contact people changing frequently without a clear reason or a handover. Last-minute communication can be an indication of a party being disorganized, but it can also mean that they're not truly paying attention to the contract at hand, and this could cause you issues down the track as well, because that's not a great way to enter into a contract. In terms of their prior work, so reluctance to share details of what they've previously done, or they're vague about their capabilities and their processes. So they can't give you specific examples of where they have provided similar goods or services which are similar to the arrangement which you're wanting to enter into with them. Another key issue, and probably a major one here, is the reluctance to participate in verification processes and deliberately concealing or refusing to provide material information. If you've asked a key question about the other side of the contract or the arrangement you're going to enter into, and they consistently refuse to answer a very key question, this is something that is worth investigating further if you can. We also often see unreasonable positions in contracting, and while some of these are just how parties deal with things or how their lawyers might go about dealing with things, again, all of these together with some of the other red flags we've noted are things that should make you perhaps think twice. So refusing to compromise on terms, not wanting to meet in the middle on certain things or find a mutually agreeable way forward, demanding terms that don't match market standard and what would usually be expected, constantly changing their fundamental requirements mid-negotiation, as well as creating artificial urgency or threatening to walk away frequently if they don't get what they want. The other one we also see is trying to shift risks, so all of the risk onto one party, so the other party essentially is taking on nothing. The reality is, in a commercial arrangement, that both parties will need to take on some risk in some respect, and it's just a matter of how you find that balance, usually through a negotiation. Also is underpricing or overpricing significantly without true justification, and promising delivery schedules that could seem impossible. From a financial aspect, so poor credit references, refusing or asking for requests for large upfront payments. Have they recently formed the company, and do they have a history of dissolving and reforming companies? This can clue you on to potential credit issues or liquidity issues. Obviously, just because a company is new, that doesn't necessarily mean it is a red flag or there's a risk. It's, again, looking at the context as a whole. It is not unusual for people starting out in business to create a new company and want to get up and running with trading. So that's where having that conversation with the other side, asking those key questions and figuring out why that company is new and what it is that they're doing can satisfy that red flag to make sure it's not actually something you need to be concerned about. If they're starting to talk about cash flow early on, so mentioning that they have payment difficulties or cash constraints, that can be something that is worth looking into further. Same with when you're having conversations with them, whether there's an obvious lack of equipment, systems, or the expertise needed to carry out their side of the contract. Also, not understanding the required licenses, certifications, or compliances that they will need to have in order to perform their side of the contract. If they're unwilling to protect your confidential information appropriately, then that is also a big issue, especially if you're going to be the party who is disclosing confidential information. And then if they won't commit to agreed principles in writing, so it's not uncommon for parties to have a memorandum of understanding or a term sheet which sets out key aspects of their arrangement. If you can't get them to commit to that in writing, then getting them to commit to a signed contract may also be a bit of an uphill battle. If they have inadequate insurance based on your discussions with them, that can also be an issue, because it may be that something happens, they don't have the insurance to cover the risk, they also then don't have the funds to do so, and you may end up being liable or taking on that loss, which is not ideal. Another key thing to consider is that if negotiating the contract is difficult, then performing it may be even more difficult. And when you're negotiating a contract, that should be, I guess, the most prickly time in your relationship, and you want to have that go smoothly, and that should set up a smooth contract, hopefully, going forward. And you should always trust your instincts about concerning patterns. So what do you do where you've entered into a negotiation for a commercial contract? There's been several of these red flags pop up, and your gut is telling you, oh, I don't know if this is a good idea. I'm setting myself up for some risk here. What can you do to protect yourself? So something you can do here is ensure that you do your due diligence on your counterparty, especially where the contract is of high value to you or involves you taking on more risk than usual. And if at any stage prior to signing the contract you have concerns, you should ask questions to try and allay those concerns or even pull out of the contract. I wouldn't be afraid to walk away from a contract if you've got a bad gut feeling and a whole lot of red flags and you've got professional advisors saying this is not a good idea. Walking away is not necessarily a bad thing in that situation. If you did want to sign a contract that you were unsure of, you can always make it conditional. So this is very common, normally in an M&A context or business sale and purchase context, where parties would sign a contract and it would be subject to a number of things taking place, such as the purchaser being satisfied with due diligence. You can do something similar in commercial contracts. We don't see due diligence being overly common in, say, a supply of goods arrangement, but you can put other conditions in there, which would mean if they're not satisfied or the other party can't prove that they can perform their side of things, then you can terminate the contract and walk away without loss. And now Natalie is going to talk about early warning signs from a dispute aspect of things during a contract term.
Thanks, Kathryn. Yeah, so now we're going to turn to a more disputes perspective for the rest of the webinar. And we'll run through first the red flags and then, what to do when things go wrong. So identifying contract warning signs early, I think, allows you to address these issues before they become costly disputes. So as Kathryn was saying before, it may not be determinative if there's one red flag, but a bunch of red flags, could cause more issues, but one can also cause an issue as well. So it's always good just to be on top of them. In the disputes team, what we see as red flags is what is going to lead to a dispute or what's already happened when disputes come to us, and that's a payment failure. So late payments, partial payments, or even payment disputes where they're disputing the invoices, potentially the amount or the potential work with that particular invoice, and communication breakdown. So when the other party potentially starts ghosting you, or they become, combative, agitated, or even aggressive, or they're frustrated with the situation. So the communication can also look like delayed responses to emails and calls, evasive answers, and a failure to attend meetings or even attempt to schedule those. And while those are the two, key ones that we see, which show a potential for a dispute later on down the track, there are plenty of others. And that also includes, requests to vary terms or change things without proper documentation. And this can cause issues for future enforcement. You always want to document any changes to your agreement or what was agreed between the parties. Failure to meet particular deadlines or quality or delivery issues and delays. Now, those are really key ones too, because those can be a breach of your agreement. And so that is a very big red flag there if those terms have been already breached or about to be breached because of those red flags. And there's another one there, which is financial stress indicators. So this is, is the other side facing financial difficulties? It's always a good idea to be aware of what your industry is doing and doing your due diligence on the industry as a whole. Is everyone going well, or is it a kind of a sign of the times that a lot of companies in the same industry aren't doing too well? So that's also a red flag, especially when payments stop coming. And while it's easy in practice to indicate these red flags, when you're busy and you have other things at the forefront of your mind and you're trying to run a business, they can often, be missed. So to assist with managing this, you want to put in some processes that help you monitor and manage these red flags as they appear. And this can include specifically with payment, payment tracking and follow-up procedures. So that would be following up with debtors. You can call them, email them, you can automate the telephone calls, and just prompting them to make payment, or even prompting them to have a discussion as to why that payment is late, or what's going on. And it allows you to address the problem early, instead of letting it go on for a long time. There's also, you want to maintain email trails as well, especially if you are trying to seek payment or specific actions. If they're disputing it, it's great to have that in writing, or if they're not disputing it, that's also great to have in writing, for later on. You also might want to automate your invoices and alerts. So there's lots of accounting software out there that allows you to automate these reminders, and it takes the thought process out of it, and it's a very helpful admin tool. Another one is relationship management protocols. So you should understand from the outset who's running this contract, or who's going to be the point of contact for this, and potentially establishing a relationship manager to oversee that contract and be the one looking out for those red flags. And there's some legal strategies just up there as well that we wanted to highlight, which even though the other party is potentially showing red flags or the agreement might have been breached, it's important that you come to the table with clean hands. And what I mean by that is that you don't start breaching the agreement because they have. You want to be in your best position, which is that you're complying with the terms of the agreement or what was agreed, and you're just wanting to show that you are the innocent party here. So always try to come to the table with clean hands, despite what's going on. And the golden rule, which the golden rule is, it's never too early to speak to a lawyer. Early advice is preventative medicine, and it's cheaper than the cure. And that cure is, further legal proceedings or alternative resolutions and incurring costs. So it can get quite costly. And you don't want to wait until the relationship is completely broken down before you seek advice. So, lawyers can help you negotiate. We can send formal letters setting out your position, demanding specific actions, and we can help you at each step of the way. And that's good if it does get to court, because at least you've had some guidance and clear documentation. So in terms of alternative dispute resolutions, this is, a really good risk management tool, because where a dispute arises, you do have options to enforce your agreement. You can send the formal letters, as I was saying, but if it does come down to a dispute, there is negotiations, mediation, and arbitration. And those are, as Kathryn was saying, what's going to be in your agreement. When you have a dispute, it will tell you what the parties have agreed to from the outset to do once there is a dispute. So I think the first step realistically is often negotiation. But when you start negotiating, you should really have a good understanding of your position, and you should document everything, including those verbal conversations. And just be aware that what you're saying in these verbal conversations could potentially create, binding obligations. And as part of your negotiations, you can mutually agree to modify contract terms, so pricing, deadlines, specifications, or potentially you can mutually terminate the agreement and decide on a defined consequence of that. And this should always be recorded in a settlement deed, as it just provides the extra layer of protection and shows what the parties have agreed to. Now, if negotiation fails, there's other dispute resolutions like mediation. So mediation is a voluntary and cost-effective process where a neutral facilitator will help the parties reach an agreement. They don't make a decision for you, they help you make a decision. And arbitration is another tool, but that's where an arbitrator makes a binding decision. So it's particularly useful in specialized industries like constructions, as arbitrators often have expert knowledge. So that's something to consider as well when you are drafting your contracts. Is your industry more towards arbitration, or is mediation going to be more effective for you? So before commencing alternative dispute methods or even court proceedings, you should really be considering your position and strategy. So that includes evidence requirements. Do you have your initial contract? Do you have all the variations in writing? Do you have potentially a chronology of all the issues that have been happening and correspondence that shows the breakdown in the relationship, or them not going to resolve or disputing things? You should also have financial records to show any loss that's been happening or any non-payments, which is always good if you do get to court and need to quantify damages claims. And yeah, again, you just need to understand your claim. Who are the parties? Is it an individual? Is it a company to company business arrangement? What breaches have happened and what terms support your position? Those are all really important factors to know before entering into negotiations as a first step as well. And you should always just gather and organize all the relevant facts and evidence, especially, as I was saying, a chronology is very helpful, setting out what's happened between the relationship. And you should understand your rights and remedies under the contract, and also just your obligations. What were you obligated to do? What were you liable for? And vice versa on the other side. So here are some other strategic considerations when you are potentially considering enforcing your agreements. And that is, what's your primary goal? Are you wanting compensation, prevention, punishment? Can the defendant, sorry, I say defendant, but can the other party actually pay or perform? Do you need urgent relief to enforce this, or can you wait for mediation or the negotiations? And is it commercial for you to pursue enforcement or the debt? Is it going to be good money after the bad? That's a very key consideration to have. And you also want to consider your relationship. Are you trying to maintain this? How do you want to come across? Because that will really inform what you decide to do when you're enforcing. There's also limitation periods, so you should be mindful that there are limitation periods to bring claims if you are wanting to enforce through the courts. And for contract breaches, that's typically 6 years. So you want to make sure you're bringing them well in advance of that, and that you're on top of these disputes as much as possible and on top of your agreements. And some other considerations there are just, is there a personal guarantee or security that's been agreed to on top of the agreement terms? And is the defendant financially stable? Are they going into liquidation or bankruptcy? So yeah, all considerations to consider before, all considerations to consider, but sorry about that. But they'll factor into how you enforce the contract. So turning now in terms of debt recovery options and what you can do. So there's formal demand letters, and this can be sent by lawyers or debt collectors demanding payment by a certain time frame. This can generate payment plans or negotiated settlements, and payment plans can be quite good to get at least part of the payment back. There's statutory demands, undisputed, that needs to be undisputed. It must be owed by a company and not exceed it must exceed $1,000. So there's a couple of things you have to get right if you do want to do that. So it's not a silver bullet if you get it wrong. But those are good options in terms of debt recovery. You also can pursue or enforce your agreements through the court. So you've got the standard process, very standard process there, which is your statement of claim, your statement of demand. if no statement of demand is filed, potential for you to apply for a default judgment, which is a judgment made without the statement of defense, which can sometimes be very cost effective. But that's if the defendant doesn't put their statement of defense within a certain time frame, which is directed by the court. You then have your proceedings, and then a judgment is made. What your goal is will determine what remedies you will seek in terms of enforcing your agreement. If enforcement is no longer an option, potentially damages might compensate you for the contract that's fallen over. So you might want to claim monetary relief there. If you're trying an injunction is a court order to enforce a legal right and compel a party to complete a certain obligation or prevent them from taking certain actions which would cause harm. So this goes back to the speed consideration. Do you need to enforce something to preserve the status quo and prevent irreparable harm that couldn't be adequately compensated by damages later on? So this could be that the contract's about to be breached, or you need to protect your IP. Those are things where an interim injunction, which is a temporary injunction, could help to preserve the status quo and prevent someone from taking certain actions, which is in breach of your agreement. And then there's specific performance. So this is another way through the courts you could potentially enforce your agreement. And this is where the court will compel someone to fulfill their contractual obligation, essentially. But this is quite an exceptional remedy, and it's only really reserved for situations where money cannot adequately address what's happened. And I'll just briefly touch on this because I know we're slightly running into question time. But you also want to consider your security interests. From the outset, you may have entered or received agreed to a security agreement or a personal guarantee. And typically those are in your base agreement as an attachment. And we always recommend these, but again, they're not a silver bullet. You do need to do your due diligence and trust your gut. There's a lot of, in terms of enforcement, external factors that do come into play, unfortunately, with these. So you have to consider if the other side is insolvent, the money you're going to receive for this enforcing the security might not be high, especially if there's employees, if it's a company, banks might be ahead of you and they might get a bigger share of the pot. So that's something to consider. And then with personal guarantees, if they're going bankrupt or the company went into liquidation, how much money is realistically there for you? So those are some things to consider as well when you want to enforce your agreements and the options that you potentially have open to you as well.
Fantastic. Well, thank you so much, Natalie and Kathryn, for that informative webinar today. Just before we jump into Q&A, please, everyone, feel free to download our Guide to Resolving New Zealand Disputes Guide just by scanning the QR code right here. Always a good resource to refer to. And please join us for the next webinar. It's coming up in a couple of weeks. Ask a Cap Raising Lawyer, Seeds, Series A and beyond. I myself have benefited from this type of advice in the past, so yeah, please jump onto that one in 2 weeks' time, and you can register now using the link below. Now, before I quickly jump into Q&A, I just wanted to take a moment to talk about our LegalVision membership offering. We have a really unique, tech-driven, innovative model here at LegalVision where you can get access to a legal team at your fingertips for an affordable, consistent monthly fee. No surprises. That will give you access to unlimited document drafting and reviews, unlimited legal advice consultations, trademarking, all of your business as usual legal needs as you grow. So yeah, please feel free to claim your complimentary legal health check and we can talk to you about how we could assist your business moving forward. We'd love to get to know your businesses in more detail, and to claim it, just complete the survey at the end of this webinar. Now, I'm going to hand over to Kathryn and Natalie for the Q&A.
Thanks, Mike. So please submit any questions you've got in the question and answer box, and we'll answer them as we go. But we have a few pre-submitted questions as well, so we'll talk through some of those. So I've got one here which says, our business has developed bespoke training resources and may launch a digital app. How can we ensure the IP is protected when sharing these materials with client subcontractors or other organisations? So this goes back to the point I made at the very beginning about key clauses to have in your contract. So you'd want to be very clear in the contract with any of those clients, subcontractors or partner organisations who owned what IP, the fact that you were going to retain ownership, and how those persons could use your IP. If you're not quite at the contracting stage, then what you can do is enter into an NDA, so non-disclosure or confidentiality agreement, which makes it clear that to the extent you share any of your IP when you're just entering into preliminary discussions prior to contract with any of these people, then they are bound by confidentiality obligations. So they can't go and take your IP or your confidential information and pass it off as their own. If any of those persons did take your IP and try and commercialize it, or you pass it off as their own, then you would have a contractual remedy in your contract or the NDA that you could then enforce. You'd be probably able to get an injunction to stop that person using your IP further, and then you could seek damages as well. And those would go through the strategies that Natalie spoke about as well. Okay, Natalie, is there any that you'd like to?
Yeah, sure. So I think this one's more an administration one, but just how to set up account paperwork and get paid. There's just a lot of accounting software out there. There's, I think, Xero, Beanie, Henry off the top of my head. But you want to probably just have a look what suits you and your business needs, and how much you want to pay. And I guess, just ensure when you're invoicing that you're invoicing the correct entity. Look them up on the Companies Act, make sure you've got the right company name and the directors and address when you are invoicing. It's very important for later on if you do want to enforce. And in terms of, there's another one here about verbal contract enforcement procedures. So, verbal contracts are legally binding provided they meet certain criteria, mutual consent, an offer and acceptance, consideration, something of value is exchanged. But if lacking that tangible record, it can be harder to enforce, and there's likely to be disagreements over what was agreed between the parties, especially if it's just a he said, she said. To enforce it, you'd want to be able to show the intention of the parties and the conduct. Does the conduct show the intention to be bound by the what was agreed, and what does the conduct show that was agreed? So, I mean, while I wouldn't recommend just keeping your agreements verbal, you should at least jot them down, or as I would always recommend, having an agreement in place. But either way, there should be some documentation or record of what was agreed in that conversation later on down the track.
Thanks, Natalie. We've got another one here which says, I have a global freight business, and you had a situation where a container was shipped from Vietnam to Germany, and then items were delivered upon arrival. The shipping company and freight forwarder refused to take responsibility, and thankfully your customer had insurance. So how else can you deal with that situation besides having insurance? Well, obviously insurance is very key, and in this situation it demonstrated exactly why parties should have insurance. But that's where you look at the terms of your agreement with your shipping company and freight forwarder, and that goes back to that allocation of risk. Who's taking on the responsibility? Who is liable for what? I am aware that large shipping and freighting companies probably have contracts which are quite take it or leave it, and they would refuse to take on further liability. But if they're refusing to take on anything, then at least have a lawyer review those contracts so that we can discuss it with you, point out where the risks are, and then you can try and mitigate against those risks on your end.
Mm. And there's one other question here. It was about how much of the law of disputes comes down to the amount of evidence and legal reasoning. And so this person has had an experience with small claims where mediators, didn't appear that they knew the law, and they instead are relying on what likely happened. So you got to remember, when you are choosing your alternative dispute resolutions, that mediation, they're not there to make a decision for you. They're there to help you facilitate a resolution with the other party. So you'll be wanting to present your case to the mediator, and the other side will do the same, and then they'll be trying to facilitate that agreement between you. When it comes to courts and arbitration, they're going to make binding decisions on you, and they're going to be looking at the facts, the agreement, and the law. So they're very different. A mediator won't be making a decision for you. So you do have to remember that they're just there to facilitate resolution. And a positive of mediation is that you can have, and on the other foot is, you can have creative and more flexible resolutions happen. It may seem unfair, but it also gives the parties a chance to reach a resolution that might be a bit more flexible. But if you don't want that, there's other options out there to consider.
Thanks, Natalie. We've got one here about it's harder and harder to collect debt, and particularly when people know the system, you just end up with a car that's not great to try and recover your debt. So obviously that's a very frustrating position for you to be in. This is where sometimes having security can be useful. So that's where you can rely on a personal guarantee, or perhaps a Personal Property Securities Act registration, so a general security agreement or a specific security agreement, and that would be from a third party. I know that's not always possible to have in practice, and as we've discussed, that third party may also be insolvent or lacking in assets to pay out. But essentially, you would want to cast your security net as wide as possible, which is, I guess, what the banks do. And if any of you have got a mortgage or a business with lending, you'll know that the banks like to have guarantees as well as things called general security agreements over all of the assets, so that if you didn't pay, then the bank can go to any one of those other avenues. So I guess that's probably the key thing there, is to expand your security net, or the number of people that you can go to claim a debt should the party that you're directly contracting with fail to pay. I should also add to that we do sometimes see people registering caveats over properties that the other parties own. So there's a standard to be met in terms of whether there's a caveatable interest, and I won't go into the detail on that now. But if you put a caveat on somebody else's property, that actually stops them from dealing with that property. So they can't go and on-sell it until the caveat is removed. So that can be another way to, I guess, force a payment, as you're stopping them being able to sell their house, for example, if they wanted to do that until they've paid you and you take off the caveat. But again, that's quite a unique situation in a relatively specialist area. So definitely seek some advice before you go down that route. Are there any others? I think we're about out of time there.
Yeah.
I think that might be a wrap. If anyone else has a question, feel free to drop it in the survey afterwards, as well as if you'd like to claim that compensation offer. Please do so in the survey. Chuck in any questions, and we will get back to you shortly. I want to say a massive thank you again to Kathryn and Natalie for such an excellent, informative webinar, and we hope to see you at the next one. And thank you so much for joining us today.